Welcome, everybody, to arbitration or litigation, what your company needs to know. I'm sorry to be the one breaking up the socializing. I know that that's always the most fun part of the day, at least it is for me. And some of you may recognize me from this morning. I am indeed pulling double duty today. I'd like to introduce my colleagues. David Elliott, who's a litigation partner in our Ottawa office. He has a broad litigation and arbitration practice and focuses on disputes ranging from shareholder to employment to IP disputes. I know that he has excellent arbitration precedents because I have recently relied on them. And to my immediate left is Rachel Howie, the head of our arbitration group in Calgary. So we have a cross-Canada panel today. Rachel's practice focuses on arbitration, both international and domestic, and she speaks frequently on arbitration issues, including those that we will be dealing with today. I am a partner in the litigation group here in Toronto. I have a tech-focused practice, but also focus on arbitration and the enforcement of arbitration awards. Our presentation today is really divided into two parts. The first half is going to address the recent case law on the debate between arbitration versus litigation and when you can or cannot arbitrate a dispute, notwithstanding an arbitration clause that you might have in the relevant contract. The second half of the presentation is going to focus on drafting clauses, and in particular, the various procedural rules and administrative bodies that you can specify in your arbitration clauses if that's how you're planning to proceed, and the pros and cons of those various rules and procedural bodies based on the type of dispute that you may be expecting. Dealing with the first question, which is arbitration versus litigation, the starting point for this is really that you already have an arbitration clause in the underlying contract that's in dispute. And the question that we're going to address is when, notwithstanding the existence of that clause, a court may say that you are not allowed to proceed to arbitration. And we'll be addressing four broad categories. The first is statutory restrictions. The second is unconscionable contracts or unconscionable arbitration clauses. The third is contractual restrictions on arbitration, which could mean various things from ambiguity in the arbitration clause or having carved out a particular subject matter to be the subject of litigation. And the fourth is timeliness of raising the issue of arbitration if someone has already started litigation. I'll be covering the first two topics, and then David will be covering the second two. Dealing then with statutory restrictions, the starting point for this is really a 2000, well, I'll back it up because I think the starting point actually isn't case law, it's the statutes. And so most provinces have both a domestic arbitration statute and an international arbitration statute that govern the process if it's domestic or international. And under the Domestic Act in Ontario, Section 7 sub 1 provides for a stay of any litigation where there is an arbitration clause. And Section 7 sub 2 then provides for exceptions to that, where, for example, the contract or the arbitration clause is not valid. And so one reason why an arbitration clause is invalid is where there are statutory restrictions that preclude arbitration. And you'll see up on the screen, we have three broad categories where there may be statutory restrictions. I think we can certainly say for consumer protection, there are statutory restrictions. And the starting point for that is the 2011 decision of the Supreme Court of Canada in Seidel. And in that case, the court was considering the BC consumer protection legislation, which provided a remedy that allowed a consumer to go to the BC courts if it had an issue. Section 3 of the BC consumer protection legislation then had another provision that said that any contracting out of the rights or remedies under that statute would be void. In other words, parties can't contract out of the remedies under that statute, including the remedy of being able to go to court. And so in that case, the court held that the consumer protection claims under the BC legislation were not the subject of the stay and could proceed in the class action that had been commenced. The other claims under other statutes and under common law were the subject of a stay, however, because there was no statutory restriction that precluded arbitration as there was under the consumer protection legislation. Now, it's worth noting that Ontario has similar restrictions on contracting out under Section 7 of the Consumer Protection Act. Now, I hesitate to read from decisions except when I'm in court, but I think there's one choice passage, which is that absent legislative intervention, the courts will generally give effect to the terms of a commercial contract freely entered into, even a contract of adhesion, including an arbitration clause. And so, in other words, the courts need to find that there's explicit statutory exceptions to the that would preclude arbitration. Interestingly, there was a strong dissent in the Seidel case, which said that the provisions of the BC Consumer Protection Act didn't provide that type of explicit exception. And I think that that's a debate that we continue to see in the case law as to what constitutes a specific enough exception that would not allow a contracting out. And so everyone was living with the Seidel case for 8 years, and then fast forward to January 2019. So I think everyone was operating under the assumption that consumer protection claims likely could not be arbitrated. But again, fast forward to January 2019, and the Court of Appeal issues its decision in the Heller case, which concerned whether or not the Employment Standards Act applied to, in this case, drivers in the gig economy, and whether or not, and the issue on the motion before the Court of Appeal was whether or not the class action had to be stayed in favor of arbitration, because for two reasons. The first was that it was contrary to the provisions of the Employment Standards Act, which did not permit a contracting out. And secondly, that the arbitration clause in that case was unconscionable. The dispute resolution clause in that case provided first for mandatory mediation, and then if that dispute could not be settled within 60 days after the request for mediation, such dispute could be referred to and shall be exclusively and finally resolved by arbitration under the rules of arbitration of the International Chamber of Commerce, and the place of the arbitration was in Amsterdam. And the Court of Appeal also noted that the fees for commencing that arbitration could be up to over $14,000. And I say that only because that was something that the Court of Appeal seemed to be focused on in that case. And so in its analysis, the Court of Appeal looked to the Employment Standards Act, and in particular, Section 5 of that Act, which provides that no employer and no employee shall contract out or waive any employment standard. And so then the question was whether any employment standard was being waived through this arbitration clause. And the court found that there was one that had been waived. And in particular, that was the rights under Section 96 of the Employment Standards Act to seek an investigation by the Minister of Labor, and that therefore the arbitration clause was invalid because it essentially meant that there had been a contracting out of this employment standard, which was the right to go to the Minister of Labor. Now, interestingly, for the purpose of this decision, the court assumed that the Employment Standards Act applied, assuming the pleadings to be true, which would, in my own view, create an ironic situation if at the end of the day, on the merits, it was found that the Employment Standards Act didn't apply, because that's the very issue in the litigation. Now, this case was heard by the Supreme Court last week, so of course this may all change. It's hard to say. One observation I have about arbitration case law is that in any given case, if it goes up to the Supreme Court, there will probably have been 6 decisions: the decision of the trial judge or motions judge, the decision of the Court of Appeal, and perhaps a dissent going the other way, and then likely 2 decisions by the Supreme Court, because it seems that the views on arbitration are somewhat divided. I'll pause here before continuing on with the unconscionability analysis, just to say that there's another recent decision out of Newfoundland that suggests also that privacy statutes might also preclude arbitration. And I'll just fast forward here. At the bottom of the page there, you'll see the legislation from Newfoundland that was an issue, which says an action for violation of privacy shall be heard and determined by the trial division of Newfoundland. So that's another area that we may see some more case law on. But all of that to say, it seems that these categories of statutory restrictions aren't closed, and that there may continue to be developments in that area. Dealing then with the unconscionability analysis in the Heller case, the court then said, even if the Employment Standards Act allowed for arbitration, we need to see whether this arbitration clause is unconscionable, which is really another way to meet the requirement of Section 7 sub 2 of the Arbitration Act to establish that there's an invalid arbitration agreement. And the court applied a 4-part test, which is first a grossly unfair and improvident transaction, victim's lack of independent legal advice or other suitable advice. Third, an overwhelming imbalance in bargaining power, which can be caused by a number of factors, including ignorance of the language of the bargain and other disabilities. And then fourthly, the other parties knowingly taking advantage of this vulnerability. Now, there has been case law since Heller was decided in January, where plaintiffs have tried to shoehorn themselves into this test. There was a case called Evans and Matamy Homes, where there was it related to real estate purchases by individual purchasers, and there's a carve out under the Consumer Protection Act that means that real estate consumers aren't protected by that act. So there wasn't that statutory restriction on arbitration, and they had otherwise agreed to arbitration. And they tried to argue that the contract in that case was unconscionable, and the court basically said, no, some of you had advice, and this wasn't grossly unfair, and these homes were for a lot of money, and this was something that you very easily could have looked into. So even though we see the Court of Appeal in Heller seemingly applying a stringent test for unconscionability, certainly there have been cases distinguishing it since then. All of that to say, I think this can impact the drafting of arbitration clauses, and certainly requires keeping in mind what statutory restrictions might apply, as well as considering what a court might or might not view as fair to a plaintiff trying to commence an arbitration against a larger company. The last recent development that I'll touch on briefly is the Welman and Tellis case of the Supreme Court of Canada that was also decided this year. And that case really addressed the question of whether or not the court has discretion to allow certain claims to proceed, notwithstanding an arbitration clause, in order to avoid a multiplicity of proceedings. And that case really concerned business plaintiffs as well as individual consumers who were protected by the Consumer Protection Act. Their claims were allowed to proceed by way of litigation because of the Consumer Protection Act, which didn't require the business claims to proceed by way of litigation. And both the Court of First Instance and the Court of Appeal had said, well, since the consumer claims are going forward by way of class action, even though the business plaintiffs aren't protected by this same consumer protection legislation, we're going to exercise our discretion to allow them all to proceed by way of class action. And the Supreme Court of Canada said that there was no discretion under the Arbitration Act, that unless there was an invalid arbitration agreement by virtue of, in this case, the Consumer Protection Act, that the claim had to be arbitrated. And so the Supreme Court of Canada said that the consumer complaints could proceed by way of class action, but the business claims had to be arbitrated. So I guess win for arbitration on that one. I think I've done enough talking. I will pass it over to my colleague David to address the other two limits on arbitration.
Thank you very much, Chloe, and good morning, everyone. We are moving now from discussion with respect to unconscionability and statutory limitations now to what parties can do themselves, which is contract. And the parties, when they contract, how that may affect their arbitration rights. And I'm going to give everyone here this morning 3 examples of situations where, because of what parties have agreed to, because of what's in the parties' contract, that has had a direct impact on their arbitration provision. In one case, the impact was to carve out a portion of a dispute, a specific type of dispute and a specific type of remedy, carving that out of the arbitration agreement and placing that in the hands of the court. In the second situation, we deal with a contract that was made after an arbitration agreement was in place, and that contract was referred to by the court in this case as a standstill agreement, which essentially froze the arbitration that had started already. And in the third situation, perhaps the most disastrous situation, there was a contract that had 2 competing clauses. And so when the application for a stay was made and the issue was put before the court as to whether we arbitrate or whether we go to court, the court essentially threw up its hands and said, we don't have a clear arbitration agreement here. There is ambiguity in the contract, and therefore the arbitration agreement is invalid. So these are all examples of how a party's own agreement can affect the rights to what would be an otherwise valid, existing, and enforceable arbitration agreement. The first case that I'd like to talk about is Clayworth and Octiform Systems Incorporated. It's a 2019 British Columbia Court of Appeal case. Actually, the first two cases are from the British Columbia Court of Appeal from this year. And this is the case dealing with the issue of carving out specific relief for a court to deal with rather than having all disputes go to an arbitration. So in this situation, Clayworth was a former employee who had left the company and had allegedly stole trade secrets, confidential information, and was in breach of restrictive covenants, in particular a non-solicitation covenant. Octiform began by engaging the dispute resolution process, which called for a stepped process of negotiation followed by mediation and ultimately arbitration. So the arbitration clause ultimately being invoked. About halfway through this process, the company presumably found out additional information and decided to commence a court action, seeking an overlap of the relief it was seeking under the arbitration provision, but also seeking additional relief and claiming conspiracy and damages. And the defendant employee responded to that by saying, wait a second, you need to arbitrate those issues. And so then the court looks to the arbitration clause, and the arbitration clause begins, as most arbitration clauses do, by capturing disputes arising out of or in connection with the agreement, but then the carve-out. Except if the company, it was specific to the company's relief, company seeks an injunction or other relief relating to the protection of the company's intellectual property or confidential information. So the motions judge was faced with two essentially competing clauses to an extent. And the motion judge focused on the clause that dealt with the court's jurisdiction and essentially found that because all of the claims being made by the company are, or could be argued to be related to the stealing of confidential information, that was sufficient to allow Octiform to continue with its claim, and so Ms. Clayworth's application to stay the arbitration was dismissed. But the British Columbia Court of Appeal disagreed with that and allowed the stay other than with respect to claims for an injunction and return of confidential information. So it stuck very closely to the carve-out provision in the arbitration agreement, but ruled that everything else should go to arbitration. And the difference between the motion judge's analysis and the Court of Appeals analysis in that case is because the motion judge really started with the court's jurisdiction clause, whereas the British Columbia Court of Appeal started with the arbitration clause and focused on that clause and defined the dispute and said that anything that falls within this arbitration clause is going to be subject to arbitration. There is a specific carve-out that we're going to honor, but aside from that, everything else will go to arbitration. So the focus was on the arbitration clause in that instance. One of the takeaways, of course, is that you can fashion an arbitration agreement with this type of provision if you want to. I'm not sure that everyone here would want to do that because I think you would effectively be guaranteeing, at least in this kind of situation, you would be guaranteeing that you would be disputing something in two forums. You would be going to court and you would be seeking injunctive relief because you have to, through the court, but you'd also be seeking damages, your other relief, in the arbitration. So assuming you have those two types of dispute, as you normally would in this situation, you're committed to two forms. So that is something to think about. But there may be situations where you do want to separate out a particular kind of dispute or a particular type of relief, i.e. injunctive relief, save that for the courts, but just be prepared that you may be faced with two different forms. The second case that I'd like to discuss is a very interesting one, also from the British Columbia Court of Appeal, 2019, Lee and Rayou. Mr. Rayou was a Chinese resident, a businessman, came over to British Columbia and met Ms. Lee. They became involved romantically. A few months later, they were married. And then along with that came the development of a real estate business between the two of them. Mr. Rayou invest approximately $18 million into this business. Ms. Lee invested far less than that. Everything was going swimmingly until Ms. Lee discovered that Mr. Rayou was already married. So this cast a shadow over not just the marriage, but also the business association that they had together. With respect to the real estate development company that they had, that was subject to an agreement that had an arbitration clause in it. That arbitration clause provided for an arbitration that would be held by the Chinese International Economic Trade and Arbitration Commission, or for short, CTAC. Mr. Rayou, though, initially commenced a court action. The dispute is all about, of course, the money that's invested in the real estate company. Mr. Rayou commences a court action seeking the return of his investment. Ms. Lee responds with her own family court action seeking spousal support. And then Mr. Rayou commences an arbitration pursuant to the arbitration clause. In the course of commencing the arbitration, Mr. Rayou's counsel seeks to have service accepted by Ms. Lee, and Ms. Lee's counsel responds by saying, "We will accept service on the condition that you agree that Ms. Lee's action, family law action, where she had commenced a motion for summary judgment and Mr. Rayou had responded with an application for a stay, those two applications would be heard before any steps could be taken in the arbitration." This is what the court referred to as the standstill agreement. So Mr. Rayou took that deal. He's essentially saying, all right, we will fight the applications, Ms. Lee's motion for summary judgment, my motion to stay in favor of the arbitration. We'll fight those, and then we can proceed with the arbitration because supposedly Mr. Rayou thought he was going to be successful. So Mr. Rayou then discontinued his own action and then tried to proceed with the arbitration without having the motion for summary judgment or his application for stay heard. And that prompted Ms. Lee's counsel to bring a motion of the kind that has rarely, if ever, been brought in Canada, an anti-suit or anti-arbitration, in this case, injunction, on the basis that Mr. Rayou had agreed not to proceed with the arbitration, had agreed not to have Ms. Lee proceed with the arbitration until these applications in the court could be heard and determined. And so that was the application that was heard before the judge in this decision, and both the applications judge and the Court of Appeal ruled in favor of Ms. Lee and kept Mr. Rayou to his bargain, the standstill agreement. And this, according to the decision at least, is the first time that Canadian courts have considered whether to grant an anti-suit or anti-arbitration injunction to enforce a contract with a forum selection clause. Lots going on in this case, but at the end of the day, the British Columbia Court of Appeal agreed with the applications judge and said, in cases like this, where we have two parties that willingly created a contract, both parties with legal counsel advising them, and we have an arbitration agreement that existed at the time the agreement was made, the standstill agreement was made. When we have that kind of situation, we are going to hold those parties, and in particular in this case, Mr. Rayou, to his bargain. And so on those grounds, the Court of Appeal did grant the relief sought by Ms. Lee and barred Mr. Rayou from proceeding with the arbitration until those applications could be heard. So that's an example of how a subsequent contract can affect, in a dramatic way, the rights that you would otherwise have under an arbitration agreement. The last case that I want to draw your attention to is a bit of a mess. It deals with a situation where there was actually two contracts in this case, but they stand for the same principle. Both contracts had what's called an exclusive jurisdiction clause, which tied basically disputes to go to the Ontario court as having exclusive jurisdiction. They also had a arbitration clause. The facts of this case are somewhat unique, and in my view, the reasons that follow are influenced significantly by those facts, not surprisingly. That's often what happens. In this case, there were 3 plaintiffs that had enrolled in the Canadian Institute of Choreactology. Does anybody here know what choreactology is? Well, I didn't either. Choreactology is a treatment, a medical treatment, that's based on changing the density of a cellular network. Now, you can go and Google this, and I think if you did Google it, you would you may be skeptical with respect to this kind of science, and that's all I'm going to say because I don't really know anything about it. It may be quite valid, but there are some critics out there, and let's leave it at that. So these individuals had entered into this 3-year program, and they'd paid a considerable amount of money. There were 2 contracts involved, as I said, both of them having arbitration clauses, and also both of them having clauses with respect to the exclusive jurisdiction of the Ontario courts. When the plaintiffs commenced an action, which, by the way, was triggered with informing the Institute that they were going to have lawyers look at these agreements, and then the individuals were expelled shortly thereafter. When the plaintiffs brought their action, the Institute decided to bring an application for a stay, relying on the arbitration provisions. When faced with these 2 competing clauses, the court found, first of all, that there was ambiguity because of the competing clauses. The court could not reconcile these 2 competing clauses. And that's something that happens in some other cases that you may be aware of, where courts will try to reconcile a clause with a governing law and jurisdiction provision with an arbitration clause. But in this particular case, because of the language in the provisions, the court found that it could not reconcile these clauses, and therefore found that there was no clear intent to refer all of these disputes to arbitration, and so found in favor of the plaintiffs and allowed the plaintiffs to continue with their action. The takeaway here is that if you have a situation where you have a contract with arguably competing clauses, in my view, you are taking a risk. You are opening up at least an argument that your arbitration clause that you would like to otherwise rely upon is invalid because there is potentially at least an ambiguity. A lot depends on what the language actually says in these clauses. The cases will turn on that. The cases will also obviously turn on the specific facts and circumstances surrounding the case. But that is something to be aware of, and that is something that I think happens a lot in terms of having at least arguably competing clauses in a commercial contract where people are using perhaps a boilerplate or a template and just regurgitating clauses that come out, and you'll see sometimes at least an opening for an argument that maybe the arbitration clause is not valid. So those are my comments with respect to the impact that contracts can have on arbitration agreements. And very quickly, I'll deal with the next issue, which is one with respect to timeliness. There are 2 cases here that both stand for the same proposition. One's an Alberta case, 2017, New Beginnings Contracting and Wedgwood Condo. The second case is also, is from Ontario, 2017, Steelwright Construction and Manshield Construction. Both construction cases, both dealt with situations where the parties initiated claims even though they had arbitration agreements in place. And those parties litigated in the courts, in one case, 16 months. In another case, I think it was about half that, a year or so. There was a delay in terms of the responding party to rely on the arbitration provision. And in both of those cases, the courts found that the delay was undue. And so therefore, even though there is a valid, existing, and otherwise enforceable arbitration agreement that could have been relied upon at the outset, because the parties in those cases, in particular the claimants, engaged the court process and the defendants responded in kind without bringing their application to stay, and that went on for some time, those parties, and in particular the defendant who would like to rely on the arbitration clause, lost the right to do so because of undue delay. So the moral of the story there is quite simple, but also very important. If you have an arbitration clause that you would like to rely on, don't wait. You have to engage that. You have to make your position known early, and you cannot, under any circumstances, allow litigation, court litigation, to proceed for really any length of time without risking the arbitration agreement from becoming essentially null. So those are my comments with respect to timeliness, and I'm now going to pass it over to my colleague, Rachel Howie from Calgary.
Great, thanks. Good morning, everyone who's here in person and everyone online. Thanks for joining us today. I know I'm the last thing standing between you and lunch, so we will try and keep this moving forward quickly. The general principle that we've been discussing all morning really is, is set up by the Supreme Court some time ago in Canada, that subject to those statutory and other restrictions that Chloe discussed, parties really are free to determine their dispute in whatever forum or whatever manner they see fit, whether that's arbitration or litigation. And looking more at this arbitration versus litigation debate, not touching on expert determination or dispute resolution boards or any of those other means of resolving disputes that are equally valid in some situations, what we'll do next is walk through a few case studies. And for that, we will need you to take out your phones. So if you haven't already, feel free to take out your phone because we will be voting in just a few minutes. And to set the stage for this, these case studies, we've got litigation, and in litigation, there's the small claims court process, and then there are the superior and federal courts, and there are rules for each of those that we're all familiar with in our own jurisdictions. Arbitration is similar. Arbitration has a range of options depending on what you're looking for, whether you're looking for something that's what we call ad hoc, which is where the parties, counsel, and the arbitrators who are appointed manage the dispute themselves, or something that is institutional arbitration, where there's an institution that is in behind the parties and the tribunal to manage and guide proceedings to differing degrees of hands-on or hands-off, depending on which institution you choose. And because of this variety and all of these options, one of the trends that we're seeing lately is a bit of a divergence and a bit of a distinguishing between institutions and between arbitral rules and options that are available to parties. And as a result of having all of these options before you, you really can tailor your dispute resolution mechanism and your arbitration clause to your exact circumstances and your exact situation. There is no such thing anymore as if you want to arbitrate, there's only one way to do it and it has to be that way. There are a variety that you can bring in. So, starting out with our, what I'll call case study number one, you're about to enter into a service contract. Given the service, the counterparties that you're dealing with tend to be well-known and established entities, but from your experience, you expect that there might be fairly frequent and relatively uncomplicated disputes. Timeliness of provision of services, amounts owing on invoices, things that are really simple, relatively speaking, with what you can otherwise see. And of course, you and the counterparties, you're all Canadian entities, you're all local, you're doing business here. So with that scenario in mind, what would your inclination be? Would it be to A, go to litigation, or B, arbitration? And if you could text code, a code to 37607, and it looks like there's a code there for litigation to text and a code there for arbitration. And just to test the system out and see how fast this picks everything up, we'll wait for a few seconds while everyone's voting. Certain things that come to mind for this type of dispute would be a very discreet, okay, arbitration is winning. That's fantastic. I'll go back. There we go. We've got some for litigation. Okay. So, to my mind, some of the criteria that might be weighing towards those voting in favor of litigation in this scenario would be that you might be dealing with disputes where, you could maybe manage these at more of a junior lawyer level. You could maybe fix fees that way. You could maybe work easier with an AFA type situation, whether you're going in stages or for a fixed or cap overall. If you're dealing with something that's in small claims or simplified procedure, you know what you're getting into in advance. And you all hear the rumors that, well, everyone tells us to go to arbitration, but then it ends up being just as costly and just as time consuming, and it's basically the same thing as litigation. Those who are voting in favor of arbitration, I'm really happy to see that, because one of the things that I wanted to talk to you about were some of the advances being made in simplified procedures under arbitration rules. And there are a number of institutional rules now that have adopted a simplified or streamlined procedure for disputes of a lower monetary value. In some instances, that low monetary value might be at $2 or $3 million, but in other instances, it's much more close to what we would think of for a small claims court matter. One of those that I wanted to talk to you about is the ICDR Canada arbitration rules. So for those who aren't familiar with it, the ICDR is the International Center for Dispute Resolution. It is an offshoot from the AAA, the American Arbitration Association. A few years ago, they set up a Canada branch, and they created a set of Canadian arbitration rules. These Canadian arbitration rules have within them an automatic, simplified procedure for disputes under $250,000 American. So for disputes that are at that threshold, you go into this, again, you can opt out of this if you want to, and you can also opt in if you want to raise that monetary threshold. So there's quite a bit of optionality there. You go into these disputes, you get a very tight timeline for the appointment of the arbitrator, tight timeline for that arbitrator to issue their first procedural order. You then need to have a hearing within 60 days of that procedural order, and then from when the close of the hearing occurs to when the award is issued has to be within 30 days. So you could potentially get an award within 3-4 months start to finish, depending on how quickly the process works. The fees are also quite low, because I know one of the things that tends to raise ire when you talk administrative arbitration is the fees that the institute collect. And of course, when you're in court, you don't have to pay the judges. When you're under these simplified procedures, there's a much lower fee schedule with the ICDR. So if you're talking something that's around, $70,000 or so, you're looking at maybe $2,000 in fees to the institute and for the arbitrator. And they have a ready list of arbitrators to hear these type of matters. So for something that fits into this category of dispute, where you might normally be thinking, oh, we should go to small claims court, or we should be thinking simplified procedure, arbitration can offer another alternative that may work better for your business. So something to think about in that type of situation. And I had an alternative situation here that we could go through where we flip the facts a little bit. I won't touch on it given our time, but the what if was just, what if you're within or slightly over the monetary limits for local and small claims courts? And in that what if, again, those ICDR rules, they have a further simplified light procedure for disputes under 100,000 American, where if you're under that monetary cap, you could proceed on paper only. So you could easily envision a situation where if you're a party who's going to be entering agreements where you might have these type of disputes that come up routinely, once you go through the first one, you have that set of precedent materials, you could easily streamline disputes going forward in a situation like this, much as you could if you were working on small claims court. And again, the other what if I had there, where the counterparties are not as established, this is an important caveat I will mention, because when you're in arbitration, one of the situations that can cause some issue is where you can't find the counterparty to serve them or to start proceedings, or if the tribunal is facing a situation where one party is defaulting and they're not participating. Sometimes that will cause tribunals to pause. It can delay proceedings. But again, depending on what rules you have and how your arbitration clause is drafted, you can mitigate against that type of situation.
Rachel, I just wanted to jump in because it's interesting how that sort of connects back into the unconscionability analysis in the Heller case, where there was this seen to be burdensome process in the Netherlands under the ICC rules, which were viewed to be burdensome. But I think what you're saying is quite interesting, that you could design an arbitration clause that actually simplifies things and maybe makes it I don't know if easier, but sort of just as easy and low cost and fast as going to court. So just touching on the unconscionability analysis, there are things that you could do in drafting, to your point with those rules.
Yeah, you can. And I'm not sure what the timelines are like in Ontario these days. I know in Alberta, you're still waiting up to a month for that up to a year for the small claims court trial date, even for the smallest of matters, given court backlogs. So again, depending on expediency and how quick you want to just clear the deck and get these things off the books, it can offer a good option. The second case study, you're purchasing a business or a part thereof. You have several carefully drafted and negotiated reps and warranties on deliverables and timing. And some of those reps and warranties are nice to have, some of them are standard, but a few are actually quite critical. And they're going to be quite critical to your ability to successfully launch the operation of that purchase business. Just pause for a few seconds and we'll do the voting again on initial reactions from anyone who does want to vote on whether you would send that kind of a situation to litigation or to arbitration. And of course, the undertone in all of this is if you're in need of those reps and warranties right off the bat, you're looking at something that touches on maybe needing to seek injunctive relief, seek some kind of urgent interim relief, seek something to keep people moving. So again, yeah, that's flipping it in favor of litigation. This touches on the Clayworth decision that David discussed earlier. Injunctive relief is typically one of those provisions that is carved out of an arbitration clause. That doesn't have to be the case. So what I wanted to discuss on this point is the advent of the emergency arbitrator. For those who aren't familiar, the last 5 or 6 years or so, a number of institutional rules have brought in emergency arbitrator provisions. And this allows a party to seek emergency, urgent relief from an arbitrator, similar to injunctive relief that you would seek before the trial of your matter. And you seek that relief before your actual arbitration starts, before your tribunal is struck. Using an example under the ICC rules, you would apply to the institute, assuming that's drafted into your dispute resolution clause. The institute then appoints an arbitrator. Their target for that appointment is 2 days. There's then a very truncated time for the opposing party to challenge the arbitrator appointment. And then the goal is for the arbitrator to render a decision within about 15 days from appointment. So things go very quickly. You can get a decision very early on. That decision could provide settlement leverage. Why would you want to do something like this? The obvious answer is it keeps everything in that arbitral framework. So if everything else is going to be arbitration, why not send this to arbitration as well? You also then maintain that confidentiality around the proceedings so that you're not filing something, airing everyone's dirty laundry in court, because injunctions tend to be quite acrimonious, even at the best of times. The flip side of this is depending on where your counterparty is operating and where you're operating and where you may need to seek to enforce this emergency relief. There is some contradictory case law globally from various countries on whether or not these emergency arbitrator awards can be enforced. So it is something you'll want to assess up front in terms of whether or not you may need to act on this. But again, depending on who your counterparty is, depending on where you are, it may be something that you would want to pursue. In addition to the ICC, there are other rules that have these emergency arbitrator provisions, and there's a variant of it as well under the LCIA rules that allows you to get an emergency appointment of the tribunal. That's a bit different. Under true emergency arbitrator proceedings, the arbitrator's functus once that award's rendered, and you need to carry on and appoint your real tribunal to hear the rest of the decision. So you do have that difference where no matter is predetermined, similar to how you would in a court. There was another alternative here, pretty much covered. Just the alternative is if you're making a purchase from an entity with whom you need to maintain a long-term working relationship. And in that situation, the confidentiality and the ability to keep things out of the public eye and out of court may actually be a factor to enforce an emergency arbitrator type of proceeding. The third case study I had is if you're developing or building a project in Canada, you need to source a key component, physical, intellectual, something from another entity. And if the component is not delivered or not delivered on time, there will be extensive costs and delays. So again, there's a timeliness factor. There's a bit of this possible need for injunction proceedings that overlays the case study. And we'll just do another quick straw poll for those who still want to vote. Any thoughts on whether litigation or arbitration would be the way to go in that one? And while these are streaming in, I'll let you all in on the big secret, which is there is no right or wrong answer to any of these. It really comes down to what works best for your business, what works best for your legal group, what works best for how your company operates, and the particular circumstances you're in. So again, litigation. Yeah, it's a pretty vanilla example. If we flip this and we go to the hypothetical change, you are developing or building the project in another country. How would that change your response? And we'll flip through. So you're now dealing in something that is clearly international, and you're actually investing and operating internationally. Yes. I would tend to agree. The initial gut reaction to that kind of situation is to think of arbitration. And this is because of enforcement issues that you might see, and also just negotiating difficulties. What court are you going to hold this proceeding in if you're going ahead? The other thing to think about in this type of a situation is the disputes arising while you're building. So you're looking at some kind of either, again, emergency arbitrator injunctive relief, or you're looking at some kind of maybe an interim measure of protection that you may need to seek throughout the arbitration proceedings. Once you're operating internationally, as I mentioned on the enforcement of emergency arbitrator awards, interim measures of protection can also be difficult to enforce depending on where you're operating. One example would be that, traditionally courts in mainland China have been very reticent to recognize any kind of interim measure of protection. So there are now some nice workarounds that your skilled external counsel can help you implement in that type of situation to try and make sure that you're as best positioned as possible. But depending on where you're actually operating and what you might be looking at, internationally, arbitration may be your better bet. The other hypothetical I had on the earlier slide is, what if you are part of a supply chain, or you're in a situation where you're at the tail end, where you might be subject to the whims of other agreements or other issues that occur down the supply chain. In situations like that, you start to think of possibly being the recipient of a claim of force majeure, where the other party can't deliver for reasons beyond their control because of one of their other business relationships or something else along that supply chain that has failed. Those types of scenarios can be very tricky to navigate through arbitration clauses, simply because you start to then have multiple parties who might have relevant documents, multiple parties who might need to be part of the dispute, multiple parties who may need to be at the table. And unless you are, for example, an owner of the project or someone who has the ability at the outset to set the stage to ensure that all of your dispute resolution language is teed up in an appropriate manner, it can be difficult to come in at the tail end and negotiate an arbitration provision that might actually protect you in all situations. The last one is also a fairly vanilla typical case study where you're selling part or all of a business, and you're selling, like you're done with this thing once it's gone, because of the nature of the assets involved. You think it's more likely you'll probably be facing a claim, whether it's a post-closing purchase price adjustment or something to do with a rep and warranty on what you're selling. And any dispute would also be highly technical and unique to your industry. So I think we have a few seconds. We can maybe vote again if anyone still wants to text in. What would your initial reaction be to that type of a situation for litigation or arbitration? Something highly technical, very unique. Yeah, this one really could go either way. What I will say as a distinguishing factor is litigation, you sometimes don't get to pick your judge. You might have a good sense of where the court might send things, but with arbitration, you can sometimes have a bit more choice in selecting the skill of your panel. There are also, in this type of situation, you kind of start thinking about where the expert evidence might fall, something that's highly technical, highly unique, will ultimately come down to a battle of experts. You have a 3-member tribunal who's very skilled. You each appoint your own member, and the off-the-cuff reaction can sometimes be, well, we've each got our own arbitrator, we've each got our own expert. It's going to be a coin toss with where the chair falls. One of the interesting developments to help mitigate against that type of situation is in the CPR rules. I'm not sure if many people are familiar with that. It's the International Institute for Conflict Prevention and Resolution. And the CPR has both administered and non-administered rules. So they have a set of rules that parties can use and then run the proceedings themselves. They also have a set of rules where the Institute will provide administrative services. And under, it's shifting a little bit towards arbitration. Under that SAT, they have a blind appointment process. And what this does is the Institute will send out a list of names to the parties. The parties will rank their selected arbitrators, send it back to the Institute. The Institute will appoint the 3-member panel. So you don't actually know which is my arbitrator, who's the other side's arbitrator. You get a skilled panel. And the CPR has procedures in behind the scenes to thoroughly vet those who are on their arbitral tribunal. So for something that is technically skilled, it's another option that I wanted to make you aware of. And that is my whirlwind tour through various options. Happy to discuss further with anyone who would like to go into more detail.